On one side of the supermarket aisle, you have the traditional UK dairy industry, deeply rooted in agricultural history. On the other side, you have modern oat drink brands, built entirely around the idea of moving past dairy. This rivalry went to court in April 2021, when the Swedish company Oatly registered a highly provocative trademark, post-milk generation. As this diagram shows, they registered the mark for 3 specific categories: food, drink, and apparel. The UK Dairy Industries Trade Association, Dairy UK, immediately fired back, applying to have the trademark entirely invalidated. Their legal weapon was the 2013 regulation, an assimilated piece of EU law that strictly governs how agricultural products are marketed in the UK. Under this legislation, the word milk is reserved exclusively for the normal mammary secretion obtained from animals. This setup creates a rigid 2-step legal flowchart. To survive, modern marketing campaigns must navigate strict agricultural definitions. The dispute eventually reached the UK Supreme Court. The court first had to evaluate ground 1 of the appeal, which hinged on a single word in the law: designation. At this first gate, the rule is clear. A protected designation like milk cannot be used for non-milk products. Oatly argued designation means the product's actual name, Oat Drink, while post-milk generation is just a marketing slogan. The Supreme Court unanimously rejected that argument. The judges ruled that designation has a broad meaning. It covers any use of the protected term on packaging or marketing when referring to the food or drink. A brand cannot bypass strict agricultural naming laws simply by burying a protected term inside a clever slogan. But there is a second gate, the proviso, acting as a narrow escape hatch in the regulations. You can use a protected word, but only if your phrase clearly describes a characteristic quality of the physical product itself. Oatly claimed post-milk generation clearly translates to the physical characteristic of being milk-free. The court found this mathematically ambiguous. Does post-milk mean there is 0% milk content, or just that the milk content is low? Second, the justices pointed out that the phrase post-milk generation describes the age and attitude of the consumer buying it. It has nothing to do with the physical liquid inside the carton. The law does not allow a phrase describing a buyer's demographic to legally substitute for physical product traits. Oatly's trademark failed the test. While the trademark failed for food and drink, Oatly did win the right to keep post-milk generation for their t-shirts. The legal reasoning is direct. T-shirts are not agricultural products, so the strict rules of the 2013 regulation do not apply to them. On a piece of clothing, the slogan works perfectly. It acts as an identity tag for the demographic proudly wearing it. In trademark disputes, the physical category of the product dictates exactly which set of rules you have to play by. This ruling dictates exactly how the modern food industry is allowed to market alternative products in the UK. The Supreme Court has drawn a hard boundary separating a product's physical reality from its aspirational marketing persona. For fair competition and consumer protection, the courts prioritize literal, traditional definitions over irony and brand disruption. A company is free to build an identity around protesting traditional industries, but they cannot hijack those same industries' legally protected vocabulary to sell their alternatives.